Let me pull it out of you. How did your wife get the curling iron when she's in the bathtub?
To be honest, sir, I wasn't even at the residence when that happened. This is stuff I discovered through the first stages of when it started unfolding, and I wasn't even at the residence when it happened. I don't know how to truthfully answer that for you.
Did you provide her with the curling iron? I mean, you pled guilty to manslaughter. How did she get the curling iron?
That was a device that was in the household.
Did you have anything to do with her death?
No, sir, I didn't.
Well, that is never a smart response when you are up for parole 20 years after pleading guilty to killing his wife. He has 10 more years left on that sentence. The ADA, Randall Myers, there, and he's going to tell the board what happened. We also have the appeal with all the details of what happened, and we will go through that at the end of his parole hearing. With that, let's jump in.
Paul Farinas, 172985.
Okay, the way this is gonna go is that I'm gonna speak to you first, and then we'll let anybody for speak, which we have no one here in favor. We do have opposition, Mr. Randall Myers, Assistant District Attorney Jefferson, and Edna Amos, victim's mother, is here with us at headquarters, will be speaking, and Joanne Barton, victim's aunt, is here at headquarters but will not be speaking. Is that correct?
Yes.
Okay. All right, Mr. Farinas, tell us, why do you think we should parole you, and what you did to get yourself in this situation?
Committed a crime of manslaughter.
Okay, be a little bit more specific than that. I mean, what did you do? What happened?
The crime of manslaughter against my wife, Delinda Amos.
And why should we let you out?
I've done a lot productively through the years of being incarcerated. Been involved in a lot of programs, classes, mentoring, tutoring, and I think I'm a different person than I was when I first came in. Mindset, way of thinking, compassionate, and I would ask the board to please consider granting me a shot at another chance in society.
Okay. All right. First, we'll go to the victim's mother. To approach the podium, please, ma'am. Please state your name and relationship, ma'am.
My name is Edna Ames. I'm Delinda Ames' mother.
Okay, Ms. Amos, tell us what you want us to know, and please try to hold it on 5 minutes.
When he first did it, they said he had 30 years flat. He said the crime that she electrocuted herself. Her 11-year-old son found her body in the tub. She not just raising her 3, but also his 2 daughters. She would never ever get a chance to see her children graduate, get married, see her grandchildren. And he had they asked him to say he's a changed person. I don't think so. Because my oldest grandchild still have nightmares, and he's 31 years old. And for a child to find his mother in that condition is beyond belief. You know, I don't think he needs to be paroled. He needs to do his 430 that they claim that he's supposed to be doing.
Thank you, ma'am. Appreciate you coming today. Next, we'll have Mr. Randall Myers, Assistant DA Jefferson Parish.
Good morning, Randall Myers, Assistant DA in Jefferson. We're opposed to Mr. Francis's request for parole. As you just heard, as victim opposition, Mr. Farinas, as noted in the judge in his opposition, had entered into a negotiated plea to serve 30 years for a violent, intentional, and carefully planned murder. and he staged a scene to try to make it look like an accident. And looking at what he's done since incarcerated, it doesn't appear that he's taken sufficient programs to warrant a release. The record shows that he's completed living in balance, true freedom program, and anger management. So based on that and the victim opposition, we are opposed to his request.
Okay, thank you, sir. Okay, this case has been assigned to Mr. Prater. Mr. Prater, would you lead us off in questioning?
All right, Mr. Prentice, tell us. I know you must not like to talk much, but I'm gonna try to pull it out of you. What have you learned in your classes about victims and victimization and that sort of thing?
Victimization, I guess, is another form of bullying. I've learned compassion. That is not right. Helping people more, listening, understanding, finding out more about myself. And finding out more about myself enabled me to be able to help others with different facilitating of classes that I've done since being incarcerated. And I've strengthened in them areas since being incarcerated and involving myself with different programs to enable me to be able to speak to you today and stating that, you know, I'm not the same person I was when I first entered prison.
Okay. Well, anytime you've been somewhere 20 years, you're not the same person that you were before. You've got some good letters from staff at the prison and the sheriff's office. You got some good letters. You got some victim opposition, DA and law enforcement. You've only served 20 years of a 30-year sentence, and you took a plea bargain. What were you originally charged with?
Second-degree murder.
Okay. How did let me pull it out of you. How did your wife get the curling iron when she's in the bathtub?
To be honest, sir, I wasn't even at the residence when that happened. This is stuff I discovered through the first stages of when it started unfolding, and I wasn't even at the residence when it happened. I don't know how to truthfully answer that for you.
Did you provide her with the curling iron? I mean, you pled guilty to manslaughter. How did she get the curling iron?
That was a device that was in the household.
Did you have anything to do with her death?
No, sir, I didn't.
That's all the questions I got.
Okay, Ms. Renata, do you have any questions?
Mr. Farinas, how old were you when this happened?
I'm 30, 31.
And how old was your wife?
29,
How old was I'm sorry.
29, I think.
Okay. No, I don't have any questions, Mr. Freeman. Thank you.
Yeah, I just have one question. I see in the record that you were removed from state police. Is that correct?
Yes, sir.
And why were you removed from state police?
It was a fight with another inmate.
And that was in 2015?
Yes, sir.
That's all the questions I have. Is the panel ready to vote?
Yes, sir.
Okay, Mr. Prater, it was your case. You'll go first.
Okay, Mr. Farinas, it's kind of an unusual situation because you're still denying something that you pled guilty to, and that puts us in a kind of an awkward position in a way, but it makes it simple also. You served 20 years of a 30-year sentence. It was a gruesome crime. The 11-year-old could have been electrocuted when they found their mom. You don't seem to have a lot of remorse for what occurred, at least not that I could hear, and you have no admission that you had anything to do with it. And so something you pled guilty to. I have no question of what my vote is going to be, and that is to deny your parole.
Ms. Renatza?
I agree. My vote is to deny parole based on the negotiated plea and the opposition expressed today.
Okay, and my vote is the same due to law enforcement and victim opposition and the plea bargain. Mr. Farinas, your parole has been denied. Good luck to you.
Yes, sir.
And we're signing off at Wynn Parish. Thank you, Wynn, for accommodating.
Thank you.
Isn't that interesting? This man 20 years ago, he kills his wife. He tries to set it up where, oh, I don't know, the iron, she somehow happened. He allows his children to find her. I mean, we're talking about the epitome of a monster, evil, pure evil. 20 years later, he has a parole hearing that lasts all of about like 11 minutes. We could see parole hearings or commutation hearings for these type of crimes that go an hour long with the supporters and it's like, then this affair is just over before it even started. And one has to wonder what goes through. We'll go through the appeal. We'll get the details of this crime. What goes through the mind of someone who you just have to assume he took the plea. You don't take a plea deal that you killed your wife in a situation where if she like this, if she hadn't, if you didn't do, come on, man, this is like, this is if there's any type of situation, you don't say, yeah, it really looks like I gave her an iron and she dropped it in the bathtub. Yeah, you're right. I'm gonna plead guilty for that because it's it's nice to see the ADA there because you hear the mother, the victim speaking, talking about her son who still has nightmares, and well, you can't heal from that. A little boy seeing your mother, a little daughter seeing your mother. It's just, and he sits there and he says, "Nope, I did not do it." I like the way the board handled this. Quick, snappy, get out of here. We're not going to waste any more time on you. And he's back in 10 years. And let me just go through this. I don't know. He probably can reapply for parole. They changed the laws recently. I'm not sure for this crime how long we'll have to wait. But if he does come back, we'll put it in the playlist, the return of playlist, where we keep track of returning offenders. So here's the facts of the case. We'll go through this. The defendant's conviction was the result of a guilty plea. A factual basis was provided by the state at the time of the plea. The state informed the court that at trial, on the merits, it would have shown that on September 3rd, 2004, the defendant killed his wife with the specific intent to kill or cause great bodily injury to her. And pursuant to this plea agreement, at the time he committed the offense, that he was acting in the heat of blood and sudden passion. In addition, the following facts were taken from the hearing on the defendant's motion for a preliminary examination that was completed a few days before his guilty plea. The preliminary examination was held on 3 days after the first setting. The grand jury had not yet returned an indictment. After the grand jury returned an indictment, the matter was allotted to another trial judge who heard the matter anew. The defendant and his defense counsel were present in court for all hearing dates. The state presented the testimony of Jefferson Parish Sheriff Officer Sergeant Donald, the lead homicide investigator, and Dr. Karen Ross, the Jefferson Parish Coroner's Office forensic pathologist and assistant coroner who performed the autopsy. The sergeant testified that officers had received a 911 call at approximately 6:46 a.m. that morning. They list an address here, so I'm going to have to block that screen out, and that's why you're not seeing anything for a second. He saw no signs of force, just YouTube stuff. No signs of forced entry. The nude victim was lying in a bathtub filled with water, with her face, including her mouth and nose, above the water, and her head resting on the back of the bathtub. The sergeant saw a pinkish froth discharged from the victim's mouth and nose. A curling iron rested on the victim's pelvic bone. The curling iron and its cord were partially submerged in the water. The cord was attached to an extension cord. By the time Sergeant arrived, the police officers had unplugged the cord. The victim's hand was cupped over the curling iron. A cloth curler used to roll hair was clipped to the back of her head. Other curlers nearby, a mirror, and a prop was propped against the toilet and angled toward the bathtub. At the time the incident was reported, there were 5 children in the home. This is so true. It's so easily one of them. So many of them could have been killed by this. This is insane. An extension cord. This guy is just, he is the brightest. He's a sharp dude. Unbelievable. Yeah, because people go and they take extension cords and curl their hair while they take a bath in a hot tub. That's just something everyone does. Of course, the police are going to think that. Yeah. Okay. Sergeant learned that prior to his arrival, the defendant was there briefly. Later, the sergeant took video statements from the victim's 11-year-old son and 8-year-old daughter, the defendant's children. It was his biological children. The son stated that the defendant was aware that the son's mother intended to leave the defendant. The daughter said that she awakened during the night preceding the death when she heard yelling and the victim and the defendant arguing. She also heard her mother pleading with the defendant to put down the gun. She stated she observed both of them in the hallway, and at the time the defendant had a handgun. The sergeant said that while he was on the scene, Robert informed the police that he was the victim's boyfriend. Mr. Johnson suspected the defendant of killing the victim. He told the officers that the victim intended to separate and ultimately divorce the defendant. He stated that the victim had either secured or was in the process of securing an apartment. The officer went to the apartment complex and confirmed that the victim had filled out an application 2 days before her death, requesting occupancy as soon as possible. The sergeant said that 6 weeks after the death, the defendant gave a statement after being advised of his Miranda and waiving them. The defendant said that he left the residence at 1:30 a.m. on the date to go to work. He stated that his wife was pouring a second bath when he left. The sergeant stated that he obtained a statement from a neighbor who saw the defendant later that morning. The neighbor's bedroom is located in front of the residence, and her window looks out onto the street. She told the officers that on the morning of the death, approximately 5:30 a.m., she was alerted to the revving of an engine on a large truck. She saw the defendant seated in the truck for a matter of minutes. The windows in her room rattled, and she considered going outside and approaching the defendant as he pulled off before she could do so. Dr. Karen Ross testified that the victim died as a result of a homicide. She attributed the cause of death to components of drowning and strangulation, but she cannot rule out electrocution. She stated that she definitely had evidence of drowning and strangulation. In her opinion, the victim died as a result of homicide violence. Yeah, she definitely strangled herself. And the whole thing is so insanely dumb. This guy's, as you can tell, there are sick people out there. And I don't know why they gave him a plea deal, because he's getting out in 2034 if he does his full term date. And then what? On June 19, 2006, the trial judge entered a guilty plea. Also, the defendant and his counsel, the trial judge, executed contemporaneous written acknowledgement and waiver of defendant's constitutional rights. Okay. He was 35 years at that time. Can you imagine? Basically, he thought the judge, in his mind, he thought the judge wouldn't give him all that time when he took the guilty plea. And then he's like, what? I got 30 years? What? And then he appealed. Clown. It's, thank you, Sir Richard, for providing this appeal. So many times in plea deals, you don't get appeals, but He appealed the sentence, and for some reason he was shocked he got 30 years with parole eligibility after serving 20. And you would think all the time he has to prepare for this parole hearing, and he decides, you know what, I'm just gonna say I didn't do it. That's gonna be my strategy. But we see everything in these parole hearings, and if you want to see more, make sure.
Let me pull it out of you. How did your wife get the curling iron when she's in the bathtub?
To be honest, sir, I wasn't even at the residence when that happened. This is stuff I discovered through the first stages of when it started unfolding, and I wasn't even at the residence when it happened. I don't know how to truthfully answer that for you.
Did you provide her with the curling iron? I mean, you pled guilty to manslaughter. How did she get the curling iron?
That was a device that was in the household.
Did you have anything to do with her death?
No, sir, I didn't.